Let's talk about this stupid bill that Congress passed today to remove, like they don't have anything better to do with their time. This stupid bill that Congress passed today to remove the Justice Taney statute. Now, for those of you who aren't familiar, Justice Taney is the justice who gave the final decision in the Dred Scott case. I'm going to actually read you some of the text from his decision. Because I know a lot of you think that Justice Taney, who are familiar with the Dred Scott case, everybody's heard about this case. But I know a lot of you think that Judge Taney was a mother effer, racist. Well, the truth is he was Roman Catholic, anti-slavery, and he felt that the states should handle the issue of slavery, which was the prevailing view of the time. But there's a really interesting website called Encyclopedia Virginia, and it talks about indentured servitude because indentured servitude was outlawed with the passing of the 13th Amendment. So at the same time you had slavery, you had indentured servitude. In fact, in the 1830s, 1840s, you had a lot of people coming over from India that were indentured servants, especially women that were indentured servants in the Caribbean, American colonies in the Caribbean, or the Americas. But a lot of people think that Judge Taney made his decision because of Dred Scott's race, because he was African American. Well, that really isn't the case because he was basing his decision on what was in the Constitution at the time. And the Constitution hadn't really defined, not until the 14th Amendment, it hadn't really defined citizenship. What qualified as citizenship. But I want to read to you first the last couple of paragraphs from this site, Encyclopedia Virginia, because you'll get a good insight here of what was going on with indentured servitude. It says here, most historians have explained this shift, talking about the shift from indentured servitude to slave labor, but those terms really were interchangeable. Most historians have explained this shift by citing either social or economic shifts in Virginia beginning around the 1670s. Morgan and others, for instance, have argued that Bacon's rebellion, which happened between 1676 and 1677, was in part the result of discontent amongst former servants. By harnessing that discontent and in the name of racial solidarity, pointing it in the direction of enslaved Africans, white elites could create a more stable workforce and one that was less likely to threaten their own interests. Other historians have observed that the flow of English servants began to dry up beginning in the 1660s and fell off dramatically around 1680, forcing planters to rely more heavily on slaves. Slavery did not end indentured servitude. This is important to note. Slavery did not end indentured servitude. In other words, the end of servitude gave rise to slavery. The historian John C. Coombs, last name Coombs, has suggested a third possibility. Quote, there was no trigger clause for the conversion, this conversion from indentured servitude to more slave labor. Instead, slavery expanded gradually as the English Empire grew, its role in the slave trade matured, and enslaved Africans became more available throughout Virginia. By the 1670s, slaves had begun to replace white indentured servants among the Virginia gentry, before both Bacon's rebellion and the sharp decline in new servants. By 1690, slaves accounted for nearly all of the gentry's bound workforce, but only 25 to 40% of the non-elites. Over time, as the supply of enslaved Africans increased and their prices decreased, farmers and planters agreed that they preferred a slave for life to a servant who had the hope of freedom. Even so, indentured servants, particularly those with specialized skills, and convict servants continued to be imported to the colony throughout the 18th century. And this is important to note because convict servants were not considered citizens. Neither were indentured servants. Neither were slaves. So that's the last two paragraphs from this site, Encyclopedia of Virginia. Actually, I have family from Virginia, Maryland, Kentucky. But let's go to the Dred Scott decision. Read you a couple excerpts here. Now, this is paragraph 3 from Judge Taney's decision. In the circuit courts of the United States, the record must show that the case is one in which, by the Constitution and laws of the United States, the court has jurisdiction. And that was the big argument. And if this does not appear, and the judgment must be reversed by this court, and the parties cannot be consent waive the objection to the jurisdiction of the circuit court. Paragraph 4, a free Negro, this is their wording, a free Negro of the African race whose ancestors were brought to this country and sold as slaves is not a quote-unquote citizen within the meaning of the Constitution of the United States. So clearly, he's looking at the text of the Constitution. What does the Constitution say about citizenship? Paragraph 5, when the Constitution was adopted, they were not regarded in any of the states as members of the community which constituted the state, and were not numbered among, quote, its people or citizens. Consequently, the special rights and immunities guaranteed to citizens do not apply to them. And not being, quote unquote, citizens within the meaning of the Constitution, they are not entitled to sue in that character in a court of the United States, and the circuit court has not jurisdiction in such a suit. Let me go to paragraph 7. Since the adoption of the Constitution of the United States, no state can by any subsequent law make a foreigner or any other description of persons, citizens of the United States, nor entitle them to the rights and privileges secured to citizens by that instrument. Let me read that to you again. Since the adoption of the Constitution of the United States, no state can by any subsequent law make a foreigner or any other description of persons, citizens of the United States, nor entitle them to the rights and privileges secured to citizens by that instrument. Paragraph 8. A state, by its laws passed since the adoption of the Constitution, may put a foreigner or any other description of persons upon a footing with its own citizens as to all the rights and privileges enjoyed by them within its domain and by its laws. But that will not make him a citizen of the United States, nor entitle him to sue in its courts, nor to any of the privileges and immunities of a citizen in another state. Now, this may sound a little racist here, but again, we're looking at the actual constitutional text. That's what Judge Taney was doing here. And again, his wording. The change in public opinion and feeling in relation to the African race, which has taken place since the adoption of the Constitution, cannot change its construction and meaning, and it must be construed and administered now according to its true meaning and intention when it was formed and adopted. The plaintiff, having admitted by his demurrer to the plea in abatement that his ancestors were imported from Africa and sold as slaves, he is not a citizen of the state of Missouri according to the Constitution of the United States, and was not entitled to sue in that character in the circuit court. And that's what Dred Scott tried to do, because he was a slave of Missouri. He was brought into the free state of Illinois and felt that because he had spent so much time in Illinois that entitled him to a right to citizenship. But according to the Constitution, as it was written at the time, he was still considered a non-citizen because of his slave status, just as an indentured servant would have still been considered an indentured servant, or a newly freed slave or indentured servant would have been considered a non-citizen. So basically they were in limbo. So that's the actual text from the decision, from the Dred Scott decision. Thought I'd share this with you, talk about this ridiculous bill that Congress passed today to remove this Judge Taney statute. Well, why don't we remove all the statutes of everybody who was on that court who couldn't come to a final decision? Because the same view that they had, 19th century view about African Americans, newly freed slaves, is the same view that they had about Italian immigrants, Indian immigrants, Asian immigrants, Irish immigrants. These groups a lot of times were lumped, and I've mentioned this before, previous video, were lumped into the same social and economic class. And I just need to make this clear. I'm not defending slavery. I'm looking at the text of Judge Taney's decision. I thought I'd share that with you. What the Constitution actually said at the time, how it was written at the time. This is before the 14th Amendment. So if you enjoyed the video, you know what to do. You can also follow me on Instagram, #JasonComposes. Not that for a one-take video, right? Or you can find me at Twitter, Culture Confederacy at Twitter. This is the Culture Confederacy saying peace out. Stay safe, everybody. God bless this thing we call the United States, and I'll catch you next time.